Today's topic is juvenile justice legal updates. We have a few announcements before we get started today. Today's meeting will be recorded and posted on the OYCR training resources page. The slides from today's presentation will also be sent to you via email by the end of the week. We welcome you to share your questions in the chat throughout today's presentation. All participants will remain muted during today's presentation. There will be designated time for questions to be answered during today's webinar. We will respond to as many questions as possible during the designated period for questions. Some questions may be combined for the sake of efficiency. If we don't respond to your question and/or you want additional information, you may email us at oycr@chhs.ca.gov. Today's presentation has been approved for 1 hour of STC credit and is pending approval for 1.5 hours of MCLE and BBS learning credit. To receive credit for attending, you must stay the duration of the entire webinar. Now, I would like to welcome OYCR's Chief Counsel, Protima Pandi, to give additional background on this webinar series and introduce today's speaker.
Hello, everybody. My name is Protima Pandey, and I'm Chief Counsel at OYCR. The Youth Justice webinar series that OYCR has been hosting are an important place for all of us to share with you the ongoing developments. And the purpose is to provide all juvenile justice stakeholders with information on practices and trends that highlight the shifting landscape of the juvenile justice field to improve outcomes for children, families, youth, and communities. Youth justice is changing rapidly in California and nationally. And our annual update series on laws and legislation, there are a lot of you today, is a popular draw. And the reason is that we all do better when we know more. So today, along with all of you, I am looking forward to learning about the legislative developments as well as some legal updates. I'm honored and blessed to work with two amazing people who you'll hear from now, my coworkers and colleagues and people that I turn to whenever I have challenging questions, who will today go through the webinar with all of you. Darius Parak is our legislative analyst. Darius is somebody who has actually spent a lot of time working in the field. He himself served on the Santa Clara County Juvenile Justice Commission and has over a decade of having worked in youth justice field. Laurent Dennis is our internal go-to subject matter experts on all things juvenile law and youth justice. Besides being a published author of a legal treatise that many of us still go to, yes, some of us actually still use books. She's also the go-to expert on the changing landscapes for juvenile justice reform. So without further ado, I think I'm turning it over to Darius. So take it away. Thank you, everybody.
Wonderful. Thank you so much, Pratima, for the introduction. And hello and good afternoon, everyone. It's wonderful to see some familiar faces, but then also a lot of faces that I haven't yet had the pleasure of meeting before. So thank you so much for joining today's session. Like Pratima mentioned, my name is Darius Parak, and I'm the legislative analyst here at OYCR. I'm very excited to have the opportunity to share key updates and key takeaways from bills that were passed during the 2025 legislative session that is going to impact California and our youth justice system for years to come. 2025 was a very, very big year. California lawmakers introduced nearly 2,400 individual bills during the first year of the legislative session, with approximately 800 of those bills becoming law. Today, I'm going to focus on a very, very small subset of those 800 bills, just 9 key pieces of legislation that reflect the legislature's continued investment in reshaping the future of our youth justice system. After I speak and cover the legislative updates, Laurent is going to have a chance to share from the appellate cases. But I just wanted to say at the top of this session that as this is an educational webinar, the bill summaries that we share are purely informational, and they do not reflect OYCR's position on a particular piece of legislation. In fact, there may be bills that you're aware of that I'm not going to cover in this session. Given the broad intersection of youth justice and our many other public services, I mean, practically every single bill could be tied back to youth justice in one way or another. So for the purposes of our conversation, we're just going to share updates from the pieces of legislation that we think might be the most impactful on youth entering, exiting, or living within California's youth justice system. Now, before I dive into it and begin discussing the bills and the process by which they become law, I did want to very quickly highlight some of the key themes that came from the past 2025 session as it relates to youth justice. These themes included the legislature's investment in, first, advancing community-based alternatives to incarceration. Second, improving educational outcomes for systems-impacted students applying for advanced degrees. And third, expanding the availability and provision of individualized, developmentally appropriate, and evidence-based services to justice-involved youth in our communities and facilities. So for those joining us for the very first time or with limited experience navigating California's legislative process, which can be pretty confusing, I thought it would be best to start this year's webinar by level setting. On this slide, you're going to find a simplified diagram of the process that a bill takes to become law. And of course, not included in this diagram is the tremendous amount of work that our citizens and legislators invest in developing, writing, negotiating, and amending bills before they reach the governor's desk. And so while some bills might reach the governor with little to no changes, there are many bills that receive amendments at every stage of the process. And so while that's not captured in this diagram, I just wanted to say that at the start. Regardless, every February, all bills to be considered for the legislative session are going to be introduced in their respective houses of origin. In California, that's the Assembly and the Senate. And from there, policy committees in each house hold public hearings, they receive public testimony, and they vote on the 2,000 plus bills introduced each year. If a bill passes out of committee, it's going to do one of two things. Either first, if it doesn't have any fiscal implications, it's going to go straight to the House floor to vote. If it does have fiscal implications, it's going to go to a fiscal committee or an appropriations committee for an additional vote. Once the bill passes through the House of Origin, whether it's through the fiscal committee then or policy then fiscal or just policy to the floor, either way, it's going to repeat the same process in the second house. And if the bill passes both houses, it's going to be sent to the governor, who can either sign the legislation into law or veto it. Over the course of this webinar, we're going to cover 7 bills that were passed and signed during California's 2025 legislative session, the regular session. And these bills became effective on January 1st of this year, that's 2026. Now, again, for those who are joining us for the first time and don't have experience with legislation, in California, bills have some pretty specific naming conventions. Each bill either starts with AB, meaning Assembly Bill, or SB, meaning Senate Bill, which indicates their house of origin. And the number after AB or SB connotes the order in which the bill was introduced in their respective house. In parentheses is the name of the author, and after the hyphen is the name of the bill. So just for example, we're going to begin by discussing Assembly Bill 243, Ahrens, so it was authored by Assemblymember Ahrens, and it's titled Post-Secondary Education, Student Financial Aid Dependency Status, Juveniles, which is a long name, and I promise is the longest bill title that we're going to cover this session, but I thought it would be important just to give an example. And so after we go through our regular session bills, I will discuss 2 key trailer bills that impact California's youth justice system. And trailer bills are pieces of legislation that make changes to California's law in order to implement provisions of our state budget. So they're separate from the type of bills that are introduced during the regular session. And unlike regular session bills, they're not introduced by a single legislator, but rather by legislators in a budget committee. And they're signed by the governor as part of the budget process. These trailer bills went into effect on June 27th of last year. So they're signed, as soon as they're signed by the governor, they go into effect, and that's different from the regular session bills that go into effect on January 1st of this year. Now, I just want to reiterate what Victoria said, that as we proceed during this presentation, please feel free to add any questions to the chat. At the end of our legislative updates, we're going to make sure to save time to answer as many questions as we can from the chat. I'm also going to make sure that I include as much information as possible regarding the particular bills, particularly some background or history. I think that's really helpful in understanding why a bill became law. And so starting with this first bill, Assembly Bill 243 Ahrens, like I mentioned. At the top right of your screen, you're going to see the chapter number, or the order in which the bill was signed by the governor and chaptered into law. And so when people are referring to bills, they're going to refer to the Assembly Bill, the number, the chapter number, and the statutes that it was passed, so statutes of 2025. And at the bottom right of the screen, you're going to see the code sections that each bill either adds to, amends, or repeals. Like Victoria said, we're going to publish all the slides after this presentation. So if you don't have a chance to capture down all of these numbers, don't worry, you're going to get a copy of the slides after this presentation. So without any further ado, diving right into our first bill, Assembly Bill 243. A little bit of background. Under existing state law, a youth's systems-involved status is kept presumptively confidential. And that's for good reason, right? The law recognizes that children have unique privacy rights, and those privacy rights are separate from adults. But this means that for systems-involved youth who are applying to higher education institutions, well, they can encounter barriers in providing proof of their status when they're trying to receive that necessary medical, educational, or financial aid accommodations. And so according to Patrick Ahrens, the assembly member who authored this bill, AB 243 was introduced to reduce these barriers to our higher education institutions for youth who are involved in the youth justice or child welfare systems. So this bill authorizes and allows a youth to request a sworn attestation of their systems involved status from a county child welfare department, probation department, or local education agency to support their application, enrollment, and obtaining of financial aid from a higher education institution. This bill also requires that all information received at the institution be kept confidential for a limited period of time, after which point the documents must be destroyed. The next bill that we're going to be highlighting today is Assembly Bill 321, which was authored by Assemblymember Schultz. This bill relates to a specific set of offenses that a court has discretion to designate as either a misdemeanor or a felony. These types of offenses that can be a misdemeanor or a felony are commonly referred to as wobblers because they can wobble between the two. And whether a particular offense is designated as a misdemeanor or a felony can have really important implications on a youth's dispositional outcomes. And so existing law authorized a juvenile court to designate wobbler offenses as misdemeanors at the time of the youth's commitment to the Division of Juvenile Justice. The Division of Juvenile Justice were the state youth prisons that the state of California used to operate, but that were closed down in 2023. And so when existing state law also required that upon the discharge of a youth from DJJ, a wobbler offense, if they had one, must have been deemed a misdemeanor for all future purposes. But since I mentioned now that DJJ is closed, this bill made technical changes to the penal code section that would control when a court could designate an offense as a wobbler, and it changed it to replace any reference with DJJ with secure youth treatment facilities. That means that for a youth being committed to a secure youth treatment facility, a juvenile court can designate their wobbler offense as a misdemeanor prior to their commitment. And should a court decide not to designate a wobbler offense as a misdemeanor, Once that youth is released from and discharged from the secure youth treatment facility, with that offense must be deemed a misdemeanor for all future purposes. And since we were just talking about it with education, one such purpose might be whether a youth has to declare their offense when applying to a specific college, for example. The next bill that we're going to be discussing is Assembly Bill 383, which was authored by Assemblymember Davies. Now, California law generally prohibits minors from possessing firearms. And this bill expands the firearm prohibitions for a very specific subset of youth that have been adjudicated a ward of the court for a specific serious or violent offense. And if they're within that specific subset of offenses, well, then it prohibits the youth from possessing a firearm until they reach the age of 30 in California. Now, existing law also specified firearm relinquishment procedures for adults convicted of felony offenses. This bill would take those existing procedures for adults and it would apply it to wards of the court who are prohibited from possessing a firearm due to that specific serious or violent offense. And just to give a few examples of these requirements, one example might be that they have to relinquish all firearms within 48 hours of adjudication if a youth is not in custody. And if a youth is in custody, well, then they'd have to relinquish the firearm within 14 days of the adjudication. In addition to expanding the prohibition of possessing firearms, this bill actually also added to the list of exemptions to that prohibition. And some of those exemptions that it added included hunting activity and education programs. The next bill that I'm going to be discussing this afternoon relates to the youth offender camps in the conservation camps that are operated by the California Department of Corrections. And so just to provide a little bit of interesting history, all the way back in 1946, in response to firefighter shortages caused by World War II, California opened up its first conservation camp. And it was staffed by incarcerated adults to assist state and local agencies in responding to fires, floods, and other natural disasters. Fast forward to today, and there are now 44 conservation camps operating across the state of California. And according to recent data from CDCR, the recidivism rates for these fire camp participants are as much as 14.5 percentage points lower than general incarcerated populations. So given the success of the conservation camp programs in 2023, CDCR developed a pilot program at the Growlersburg Conservation Camp in El Dorado County. This, for youth that were participating in the camp, they had to meet certain requirements. Eligible youth had to be between the ages of 18 and 25. They needed to have a high school diploma or a GED or have enough time left to obtain a degree at the camp. And they also had to meet some pretty stringent criteria for being placed at the conservation camp. That included not having specific offenses, which if they had them, would automatically disqualify the applicants. But after a successful first year at Growlersburg, the program was expanded to include the Pine Grove Conservation Camp in Amador County. And this bill, Assembly Bill 952, would make permanent the Youth Offender Program Camp Pilot Program at Growlersburg and Pine Grove. And it would authorize the Secretary of CDCR to expand the program to some or all of the remaining 42 camps. Again, I think a background is really helpful for describing this bill, Assembly Bill 1258, CALRA. Back in 2016, the California legislature authorized select counties to operate a deferred entry of judgment pilot program. What this pilot program allowed was transitional age young adults to rehabilitate in a juvenile detention setting and have their criminal cases, their adult criminal cases for nonviolent felonies dismissed. So at the time of their sentencing, eligible youth that consented to participating in the program and that were eligible would plead guilty. And in exchange, the court would defer or hold off on entering their guilty plea. And it would order a term of detention no longer than a calendar year in a juvenile facility. And so if the youth was successfully satisfied all of the terms of their contract, or the case would be dismissed and their record would be sealed. Should a youth be unsuccessful in completing the program, well, then the court would enter their deferred guilty plea, return the youth to adult custody, and schedule a criminal sentencing hearing. This bill, Assembly Bill 1258, reauthorizes this program, and it reauthorizes it in the counties of Butte, Nevada, and Santa Clara to operate the pilot program for eligible defendants. And these defendants have to be between either the ages of 18 and 21 or between the ages of 21 and 25 with the approval of a multidisciplinary team that's comprised of probation, the Superior Court, the district attorney, and the sheriff of the county. Now, according to the author, studies have shown that young adults between the ages of 18 and 25 are still undergoing significant brain development, and they're developing their decision-making skills. And so to that extent, the author, Assemblymember Kalra, believes that although these individuals are legal adults, they're better serviced by the juvenile justice system, where they can receive age-appropriate services as opposed to rehabilitation in an adult facility. And so since this pilot program requires the detention of young adults between the ages of 18 and 25 in juvenile facilities, this bill also requires our office as OYCR to review these pilot programs to ensure compliance with existing federal law that requires sight and sound separation between juveniles and adults. And so because they're between the ages of 18 and 25, they need to be separated from the other minors within the facility. Finally, this bill would require that participating counties submit an evaluation of their pilot programs to the Senate and Assembly Committees on Public Safety no later than December 31st of next year to continue assessing the success of this program. Our next bill, Assembly Bill 1376, makes changes to our state's juvenile probation system. In California, youth who have been found to commit specific offenses can be adjudged a ward of the court. And once they're a ward of the court, a court can make any orders reasonable to support the care and supervision of the minor. Just to provide some numbers, in 2024, that's the last available year, though there will be more information released by the DOJ this year, or I guess about last year, 2025. In 2024, nearly 6,000 wards in California were ordered to an initial term of wardship probation in a community or home setting. And that is the most common wardship disposition ordered by juvenile courts. Existing law, however, did not apply a statutory cap to a ward's term of community probation, nor did existing law require periodic reviews of the youth's progress on probation. And so according to the author, Assembly member Mia Bonta, this meant that many young people were being placed on probation for indefinite periods of time. Among its many provisions, this bill presumptively limits the period of time that a ward may remain on community probation to 1 calendar year. Now, I want to quickly pause and note that this bill does not apply to wards that have been committed to either a juvenile hall, home, ranch, camp, forest camp, or secure youth treatment facility. This bill also does not apply to wards that were committed to a secure youth treatment facility and were discharged or stepped down to a less restrictive program. So I think that I just wanted to make that important caveat. For the wards that this bill does apply, this bill authorizes a juvenile court to extend a ward's term of community probation beyond that presumptive 1-year cap if it's more likely than not to be in both the youth and public's best interest that the ward remain on probation. This bill would also require that when the probation department is requesting an extension, they need to submit a report to the juvenile court, which details all of their bases and reasons for requesting that extension request. And a ward and prosecuting attorney need to have the opportunity to present relevant evidence to either rebut or support a probation department's disposition recommendation. So once a ward's term of probation is extended, should it be extended, this bill would require that a juvenile court hold review hearings at least once every 6 months to assess the progress of the youth in meeting their rehabilitative goals. The final bill I'm going to cover this session related to the regular session is Senate Bill 413, which would expand the list of parties that are authorized to inspect and use juvenile case files. Just a little bit of history regarding this particular bill. Back in 2019, Governor Newsom signed Assembly Bill 218, which, for those who are unaware, it increased the statute of limitations for claims of childhood sexual assault against California's public agencies. And so over the past 7 years, the number of claims that have been filed alleging instances of sexual assault within facilities has risen. And under current state law, it's difficult for attorneys to access those case files. It's a very difficult process where they need to file petitions with the juvenile court, notice appropriate parties, wait for rulings by the court, redact records. And so according to the author, Assemblymember Allen, this is significantly impacting the ability for the lawsuits to move forward at an acceptable pace and preserve judicial economy. And so this bill would amend Welfare and Institutions Code Section 827. That's the Welfare and Institutions Code section that lists the number of parties that can access juvenile case files. And it would authorize attorneys and their assistants in civil proceedings that have been filed on behalf of the person who's subject to the case file. It would allow them to review that case file and inspect it. And so once upon the conclusion of this particular case and proceeding, it would require that the attorneys for the parties return and otherwise destroy all copies of the records that they've obtained as part of the process of the case. So with that, I've covered all of our regular session bills, and I'm now going to turn to discussing 2 key trailer bills that impact California's youth justice system. And just as a reminder, these bills went into effect on June 27th of last year. And the first trailer bill I'm going to be discussing this afternoon is Assembly Bill 118, which makes changes to California's law in order to implement provisions of the budget related to health services, excuse me. And so while this is a very large bill, it's an omnibus bill that impacts a number of programs, grants, and services that fall under this wide umbrella of health services. Today, I'm just going to focus on AB 118's amendments related to the California Juvenile Justice Realignment Block Grant, or JJRBG. For those who are unaware, this grant was established in 2021 to support California's counties in providing rehabilitative services and supervision services to that population of youth that I was talking about that were coming back from now the closed Division of Juvenile Justice and would now be expected to be cared for by county probation departments. And that population that would have gone to DJJ would also now be expected to be cared for by county probation. And so the JJRBG funds are used to fund programs, which includes caring for youth that have been adjudicated to secure youth treatment facilities and stepping down less restrictive programs or otherwise would have received that care at DJJ. And so of its many provisions, this bill reauthorizes the appropriation of $208 million in general funds to be distributed to California's 58 counties under the Juvenile Justice Realignment Block Grant. And it also revised the by-county funding formula for fiscal years 2026, 2027, and 2028. Separate from the revisions and reappropriation of the funding, this bill also made changes to the elements that counties need to include in their annual JJRBG plans that they submit to our office, OYCR. Existing law specifies that in every single county, there has to be this multi-agency body called a Juvenile Justice Coordinating Council, or JJCC. I know another acronym just to add on to everything we've been talking about today. JJCCs are charged with developing, implementing, and allocating funding to the continuum of county-based responses to youth crime. They're chaired or co-chaired by the chief of probation in the county, and they include, just to name a few examples, they will include representatives from the district attorney's office, public defender. They also need to include members of the community. And so every year, a county's JJCC has to develop and submit to our office an annual JJRBG grant plan. And this bill, AB 118, now requires that these coordinating councils include in their annual plan a description of the less restrictive programs that are being utilized by the county, as well as an accounting of all expenditures, JJRBG expenditures from the prior fiscal year. This bill, just continuing talking about everything that AB 118 did this last year, in addition to the changes that it makes, this trailer bill also includes a number of measures that expressly prohibit or withhold the allocation of JJRBG funds depending on the suitability findings that are made by the Board of State and Community Corrections, or BSCC, through their biannual inspection process. I'm going to talk a little bit more about the BSCC inspection process when I'm discussing the next trailer bill, but just for the purposes of our conversation right now, what's important for you all to know is that BSCC will biannually inspect facilities and determine whether or not the facility is suitable for the confinement of youth. This bill, AB 118, prohibits a county board of supervisors from allocating JJRBG funding to a detention facility if BSCC determines that the facility is or was in the prior fiscal year unsuitable for the confinement of youth, and that facility is being used to detain youth. This bill also authorizes a board of supervisors to withhold JJRBG funding from any entity that it is or was operating a facility in the prior fiscal year that was determined by BSCC to be unsuitable for the confinement of youth. So first, it prohibits funds being used for facilities that are unsuitable, and then it authorizes a board of supervisors to withhold funding from the entity that is operating the facility. That's up to the discretion of the board of supervisors. Should the entity that's operating the facility cease confining youth, or should the facility be found by BSCC to have remedied its unsuitable conditions, well, then the Board of Supervisors may reallocate JJRBG funding. The final trailer bill that I'm going to be discussing this afternoon is Assembly Bill 134, Public Safety, and it makes changes to California's law to assist in implementing provisions of the state budget related to public safety. As with the last bill I was discussing, AB 118, this bill also relates to the Board of State and Community Corrections and their oversight authority. As I mentioned, every 2 years, BSCC begins its biannual inspection process of California's 132 active juvenile detention facilities. And these facilities are inspected for their compliance with California's Title 15 minimum standards of detention. This bill, among its many provisions, clarifies that BSCC has the authority to conduct additional inspections on top of the inspections that it needs to do every 2 years. And should a facility be found in non-compliance with Title 15, well, then the facility needs to submit a corrective action plan, or a CAP, to the board, which outlines how the facility will correct the item or items of non-compliance. This bill authorizes the board to delegate the authority to approve or disapprove of corrective action plans to the BSCC executive director or a delegated deputy director. Finally, this bill vests BSCC with the authority to first enforce compliance with Title 15, or second, close unsuitable facilities through civil suit. I just wanted to highlight a section from the bill itself. It said that BSCC is authorized to seek, quote, any equitable relief necessary to protect the health, safety, and welfare of juveniles in custody. And with that, we've covered all of the legislation that we're going to be talking about over the course of this presentation. And so as we close out the legislative updates portion of this webinar and we head over to our Q&A portion, I just wanted to end by providing an overview of the legislative calendar from the start of the 2026 session through February. California operates on a 2-year legislative cycle, meaning that legislation that was introduced but not passed during the odd number year of the session, which was 2025, has an opportunity to pass during the even number year, or 2026. These types of bills they're introduced in 2025 and have an opportunity to be passed in 2026, they're called 2-year bills, and they operate on a separate timeline from the even number regular session bills. And so on this calendar, you're going to see those separated out. Regardless of it's a 2-year bill or not, the legislature reconvened on January 5th, and on January 10th, the governor submitted his proposed budget to the legislature. The policy committees heard the last fiscal bills that were introduced in the odd number year 2025 on January 16th. And then committees reported the last bills introduced in the 2025 session to the floor on January 23rd. The last day to pass bills that were introduced in the odd number year, these 2-year bills, is January 31st, so it's fast approaching. But then the legislature will have some time, and it's not going to be until the end of February, February 20th, that they need to introduce all bills for the 2026 session. If you're curious about the other deadlines for the upcoming 2026 session, past February, you can go onto the California Assembly and Senate website, which includes all of the important deadlines. And with that, as I mentioned at the top of the session, the legislation that I reviewed today underscores the deep commitment of our state to build upon the successes of realignment and provide individualized care to our highest need youth. I hope that the information that I provided today has been helpful, and I really appreciate your attention, and I look forward to answering any questions you may have. Okay, I'm seeing a question from Carol Isaacson. Can you provide a little bit more context about the amendment to section 827? What type of cases led to the amendments? Right. So just to provide a little bit more background, I believe that you're referring to Welfare and Institutions Code, Section 827. That's the juvenile case file amendments. Those amendments came because of the rise of cases that have been occurring based on the extension of that statute of limitations for people to file claims related to childhood sexual abuse. I'm sure you've seen in the news, for instance, in LA County, the $4 billion settlement that the county has entered related to those types of lawsuits. And so this bill was just making amendments and changes to the WIC code in order to support attorneys who've been representing youth in filing those claims. Yes, absolutely. I'm seeing a question. Tara, would it be possible to post the slide with all of the bills on it? The very first one. Okay, going through, will there be any bills that will give probation officers an ability to enforce court orders or probation requirements? Because right now there are none. The bills that we were talking about today do not relate to any future bills. And so I wouldn't be able to speak on the bills that might be introduced in the 2026 session. As it relates to the racial or geographic disparities, unfortunately, we can't speculate on that. I don't know whether or not that was considered when extending firearm prohibitions. I'm seeing for AB 1258, would these deferred entry of judgment youth between the ages of 18 and 25 be housed with youth in detention? No, they would be housed in separate parts of the facility. Like I mentioned, there's federal legislation that requires sight and sound separation between adults and juveniles. And so those youth between 18 and 25 would be in a separate part of the facility. Let's see. I'm seeing from Phil, how many detention facilities did I mention? There are 132 detention facilities across the state that are in 62 unique addresses. I think it's also 42 counties, but I might be wrong on the exact number of counties, but there are a lot of facilities. I'm seeing a question about how we're making sure that the implementation of these bills, many of who have been youth lived experience and community led are being involved in the process. Like I mentioned, there are opportunities for youth to be, or for community members to be involved through the Juvenile Justice Coordinating Council. That's one example that I might suggest. And certainly, as I was mentioning at the start, there's community is involved at every part of the decision-making process, whether it's public testimony in the various policy committees in the House, or sorry, in the Assembly and the Senate. I'm seeing a question about whether the pilot program is going to expand. Unfortunately, I'm not aware of whether or not the pilot program is going to expand to other counties. I think that's certainly part of why the legislature will want to see that report that's going to be sent to the policy committees in 2027. Did you read? I'm seeing a question. Did you read the limitations on the duration of probation as not applying to youth and non? Correct. So as it relates to Assembly Bill 1376, the provisions of the presumptive limit on the term of probation will not apply to youth that are committed to a hall, ranch, camp, forest camp, or secure youth treatment facility. I'm seeing a question about juvenile hall and police department inspections by juvenile justice commissioners. I'm certainly happy to connect offline about that. I myself, in fact, was part of those inspections, and so we're always available to provide technical assistance. So if you want to send me a private message with your email, I'm happy to discuss that after the webinar. I'm seeing a question about the youth offender program camp pilot. Yes, happy to talk about that a little bit more. Like I mentioned, there's currently 2 camp pilot programs, one in Growlersburg and one in Pine Grove. There are a number of youth that are currently participating in those programs. They have an opportunity to, like I mentioned, receive high school education when attending the camp. And just as a little bit of tidbit information, those youth that were participating in the program were actually part of the brave and heroic fire crews that were supporting the firefighters in LA County. So the youth that are participating in those programs have an opportunity to really, truly support our state. Are you aware? In terms of community pathways or step-down programs, that wasn't covered in this presentation, but we do offer technical assistance as it relates to less restrictive programs. And we'd be happy to connect about that as well. Okay.
And I'll just jump in for 1 second. I think there was a follow-up question regarding whether or not the limit on probation applies to non-minor dependents and youth in placement facilities, and it doesn't apply to those kids.
Thank you, Lauren. Okay. I see one last question about JJRPG funding. It did not, the funding reallocation did not impact how counties might use that funding. It was only reauthorizing the amount of money that was previously allocated, and it changed the funding formula. And certainly counties without any youth and secure youth treatment facilities do receive JJRPG funds. Okay. With that, thank you so much for all of your questions and your interest regarding our legislative updates. I do want to make sure that I've got time for the wonderful LaRon Dennis to share her portions related to appellate cases. So with that, I'm going to pass it to you, LaRon, for your portion of the presentation.
Thank you, Darius. That was awesome. Super thorough and very interesting. As he mentioned, I'm LaRon Dennis. I'm a special consultant here at OYCR. I will do my best to make these case summaries even half as interesting as the legislative presentation was. And of course, as usual, I'm going to cover those cases that are most relevant to juvenile justice. And I'm going to start the day with an interesting case as the courts are continuing to grapple with the implementation of the new SYTF and LRP situation and those youth transitioning to their local communities. So the first case is In Re HT, and it's a case regarding a youth being released from a secure youth treatment facility in his county, but who was unable to go to the usual community options due to the fact that he was required to register as a sexual offender. As a side note, I am not really sure why that is the case. As we have experienced in the last couple years, there have been several appellate cases. In Re TO is one, In Re IB, that basically spell out that registration requirements apply to those youth who are discharged or paroled from Department of Corrections and rehabilitation facilities, not for youth that are committed locally and to secure youth treatment facilities. So I'm not sure why that was an issue in this case, but it was a problem for HT in placement. But as it relates to the facts of the case and his particular situation, when he finished his SYTF commitment at the end of his baseline term, he couldn't go to one of the two things that probation usually used, a community organization housing, because they didn't take people who had to register pursuant to PC 290.008. And he couldn't go to probation's usual housing facility, and I'm assuming that that is their step-down facility, because it was too close to a high school, which was prohibited by his probation conditions. So HT found a facility, and he asked the court to order probation to pay for him to live at this transitional facility. And initially, the court did that, even over the county's objection. But while probation was trying to explore some other options and find funding streams, HT's mom and the probation department tried to find hotel vouchers and offered those for placement. The probation department suggested using emergency shelter. The director of the transitional housing facility where HT was even offered to work out some sort of a deal with HT to allow him to stay there until he got his first paycheck because he had found some work. But after several continuances, the court didn't feel like it had the authority to order those further payments for the transitional housing, so they refused to do so. HT appealed his case and argued that the court did in fact have discretion to order the county to pay for his rent. And it covered about 24 days between that last court hearing and his first paycheck. So the first issue for the appellate court was procedural, and it was basically whether or not the claim was moot, because by the time it got to him, HT had secured housing at this facility, and he didn't get any more financial assistance from probation. So the people argued that the appellate court ruling wasn't going to provide HT with any relief because he was already in the housing. But the court felt like the point for HT wasn't just the housing, but it was also the payment that he had to make when the probation department refused. So a ruling in his favor would still provide him with some effective relief because the juvenile court could then exercise its discretion to order probation to pay HT what he had already paid out of his own pocket. So the provision at issue here is Welfare and Institutions Code section 900B. 900B, in the court's estimation, by its plain language and the legislative history, clearly authorized the juvenile court to order the county probation department to pay for the expense of support and maintenance of a ward of the juvenile court when it's found to be necessary. So in writing the opinion on this case, the court looked at Black's Law Dictionary for the definitions and some prior case law and found that the words support and maintenance include the cost of lodging and or shelter. And so here, the appellate court held that the juvenile court did, in fact, have the authority to order probation to pay for the support and maintenance of HT in the form of rent. So the case was remanded back to the juvenile court so it could make a determination about whether or not it was necessary for the county to pay HT during that 24-day period until he received his paycheck. So the next case is In Re LH, and it is another one of those cases about setting the maximum time of confinement. I feel like we have one of these cases every year. In this particular case, LH was committed to an SYTF for first-degree murder. The juvenile court committed him for a maximum term of 25 years to life, or the age of 25, whichever occurs first. That was actually the language in the order. At the time of disposition, LH had 734 days of pre-commitment credit, and after the court applied those credits to his maximum term of confinement, that 25-year period, the remaining custody time was 22 years, 361 days. LH appealed and challenged the maximum term of confinement of 25 years, and he argued that the court couldn't set the max time at 25 years because that went beyond his 25th birthday. And he also challenged the court's application of his credits. So in reviewing the case, the appellate court took a look at the provisions of 875 and analyzed them in the context of Welfare and Institutions Code Section 726 and 731, which were the statutes that previously controlled DJJ confinement periods, and Statute 607, Welfare and Institutions Code 607, which controls juvenile court jurisdictional limitations. So let's take a look at 875. So B1 is the baseline period of confinement that is set, which is, while the youth is in the SYTF, the time necessary to meet the youth's treatment needs, prepare for discharge, and that number is based on the Judicial Council's matrix, which was set based upon statute. And 875C1 is the maximum term of confinement, which is based upon the facts and circumstances of the matter before the court, and that is appropriate to achieve rehabilitation. But it's subject to the age limits on confinement, which are either 23 or 25, or sometimes that 2-year period of control, and the middle term of the adult offense triad, which would be, for example, if an offense is a 3, 5, or 7-year, then the 5 would be the middle term. And then you can add to that any aggregated petitions if the youth had other prior petitions that had been sustained. So the appellate court held that the jurisdictional age limits of 23 and 25 that you find in the C1A subdivision create a cap on the time of physical confinement, which is separate from the maximum term of confinement set by the court in 875C1B. So the juvenile court was correct in setting LH's maximum time of confinement at 25 years. And as it relates to his credit issue, 875C1C states that pre-commitment custody credits for time served are to be applied against the maximum term of confinement. So the juvenile court correctly applied those credits to the 25-year maximum term, not against the age of 25. And finally, the court held that there wasn't an equal protection issue here because, similar to the old DJJ commitments, all pre-commitment credits are applied to the maximum term of confinement. And again, in this case, that was 25 years. So moving on to In Re LG, this is a search case. A little bit about the facts. So officers are driving by, they see a group of young men, LG is one of them. The officers believe that they're in a known gang territory where they've made a previous arrest, and he is with someone that the officers know to be a gang member. So they are slow rolling. They stop to try to engage the kids, and LG refused to engage in conversation, and he won't even make eye contact with the officers when they stop. So the officers exit the vehicle because they're going to, in their words, conduct an investigation because they believe it's likely that LG has drugs or a gun, and they thought he looked nervous. So the officers yell at the youths to step out into the street and to get their hands up. One of the officers goes around his vehicle and LG takes off running. Backup officers are responding and they catch him. And when they search him, they find a gun. So a petition is filed, and in court, LG challenges the search with a motion to suppress, but the court held that the search was proper, and a petition was sustained, although the appellate case itself doesn't say whether LG then admitted the offense or it went to trial, but he was ultimately adjudicated for the gun charge, and this appeal follows. So first thing, regarding police contacts, there's a distinction to be made between a consensual encounter, which requires no justification, and a detention, which does. And when the courts are looking to decide if a police encounter has turned into a detention, the court will consider what they call the totality of the circumstances. So here, once the police gave the hands up instruction and advanced out of their car towards the youth, in the court's opinion, the situation had now transformed from a consensual encounter to a detention. And the court held that these officers did not have a particularized or objective basis to believe that LG was committing a crime. His nervousness and simply being in an area with a known gang member was not enough to create a reasonable suspicion that he was engaged in criminal activity. So the matter was remanded, and the juvenile court was directed to vacate the adjudication and grant LG's motion to suppress the evidence. Okay, the next case is kind of an unusual one. We don't get to talk about this very often. So we'll start with, what is the Kellett rule? Basically, when a prosecutor is or should be aware of more than one offense in which the same act or course of conduct plays a major role, all of the offenses have to be prosecuted in a single proceeding. And similarly, sort of related, is Penal Code 654. It provides that conviction and sentence under one statute bars prosecuting that same act under any other statute. So the facts and the specifics of this case are kind of important in making this decision. So JD, on March 24th of 2023, about 2:30 in the afternoon, approaches a group of girls sitting on the first floor of the mall. And she approaches one particular victim, takes her cell phone, and walks away. Same day, later in the afternoon, it's now 5, JD and a couple of her friends are on the second floor of the mall, and JD jumps on the victim, punches her, and takes her cell phone. So both of these incidents are recorded by surveillance camera. The first petition that was just the theft of the phone was filed in July of 23, and in February of 24, JD admits it. I get that's a long time. I guess it takes a long time in this county to do out of custody cases. I'm not sure. The second petition was filed even later. It was filed for felony assault and theft of the phone. And that was filed in March of 24, so 1 month after she had admitted the first petition. So it's filed, and JD moves to have the assault charge dismissed under Penal Code 654 and Kellett. And now if you're wondering what the delay was in the second case, that happened to be because the DA sent the case back to the police officer that had written the report for some additional information. And because that officer was out on extended leave, the DA didn't get a response for quite some time. So the court has to decide whether these prosecutions were the second one was barred. So the test to determine whether multiple prosecutions are prohibited is whether the same act or course of conduct played a significant part in the two prosecutions. So California courts use two different line of cases when they're trying to decide if the offenses occurred during the same course of conduct and are prohibited. First, were the offenses committed at separate times and separate locations? If the answer is yes, then separate prosecutions are not barred. The second line of cases and test is whether or not the two offenses need to be prosecuted together because the evidence to prove one offense necessarily provides proof of the other. So in this situation, JD's offenses were committed at two different locations within the mall, two different times, and two different victims. And further, the evidence that was needed to prove the felony assault and the theft of the second phone didn't supply proof for the first theft, and vice versa. So even though the DA could have possibly known of the multiple offenses and filed them together, it doesn't necessarily mean they did know or that they should have known. And the court held that that wasn't what was required under Kellett. It was more about the course of the conduct, not the timing of the prosecution. Okay, moving on to In Re AH. This is a case about out-of-home placement and following proper court procedure. So AH had a violation of probation sustained, and the probation report at disposition indicated that he'd been screened for eligibility for an STRTP, a short-term residential therapeutic program, due to his mental health conditions. But probation was hoping that he would also be evaluated by his own medical provider, and that if he was placed on proper medication, he could be treated in the community. So AH stayed in juvenile hall pending this evaluation. About a week later, probation files another court memo and says, well, STRTP suitability is questionable, but because mom is now stating that she's fearful for her safety if he were to come home, placement in the STRTP was the most viable option. So this second memo had 18 recommendations, several of which referenced a case plan. For example, something like probation has complied with the case plan, the court has reviewed the case plan, but in fact, there was no case plan, not attached to the memo and none of the previous paperwork. So the court says it's going to order AH into an STRTP, and the court reads and adopts the recommendations from the memo, including the ones that reference a case plan. So defense counsel interjects at this point and says, we don't have a case plan. And maybe you mean it's more like case plan recommendations are pending. But the court decides to just defer ruling on the case plan related recommendations and continue the matter for 15 days to check on AH's placement and for a case plan update. So at that subsequent hearing, defense counsel advises the court that the Welfare and Institution Code and the California Rules of Court require a case plan be submitted in advance of disposition and reviewed by the court. Counsel now objects to the STRTP as there's still no case plan. Well, the probation court officer pauses the case because they believe that the case plan has now been finished. So they stop the case, they go out, they get the case plan, which is in fact done, and they bring it back and pass it out. The court calls the case again. Now it indicates it hasn't yet looked at the case plan, but it's still, with the end result is AH has still been ordered into an STRTP. The court now continues the matter again for another 15-day review and a restitution discussion. So AH finally appeals, claiming that the court has put him in this STRTP, but has never complied with 706.5 and 706.6. So there are two procedural issues here on the appeal. The first one is the issue of mootness, because AH's placement has already now been set aside by the juvenile court before this appeal is ever heard. By virtue of the definition, it's a short-term situation. So since he was no longer in the STRTP, the case was potentially moot. But the appellate court said that when issues like these are short-lived, like an STRTP commitment, these kinds of wrongs, when they're done, could always be avoided being heard on appeal, but they can continue to happen. So the court exercised its discretion to decide the issue because it was short-lived and capable of repetition. Okay, the second issue is whether or not the case his appeal should be forfeited because they didn't raise the issue or timely object to the STRTP placement. Because the issue was raised at that follow-up court hearing and not at disposition, the court felt like, yes, the issue probably was forfeited, but because this was an issue of pure law, a question of pure legal question, and there hadn't been a published case on it yet, they authorized their discretion to go ahead and rule on the case. So those two procedural things aside, let's take a look at the relevant statutes and talk about the merits. So first, 706.5 of the Welfare and Institutions Code, when foster care is recommended by probation, the social study that is received into evidence at disposition shall include a case plan. And under 706.6, a case plan is developed with a child and family team. It needs to be attached to the social study or incorporated in it. It provides a description of what led the youth to potentially need to be placed in foster care. It documents all the pre-placement efforts and assessments of the family. Neither of those things were done here. And finally, California Rule of Court 5.785 requires a case plan if probation recommends foster care, and it must be provided to the court clerk to disseminate 48 hours prior to disposition. That didn't happen either. So the appellate court held that neither probation or the juvenile court complied with this statutory scheme, and that placement of AH in the STRTP was an abuse of discretion. However, he had already completed his term, so. Okay, the next case is RD versus Superior Court. So this is the first case that I'm aware of where the California Racial Justice Act has been published regarding a juvenile case. So I want to say we're going to go into it pretty thoroughly, although the statute has been amended a few times since this case. But I'll give you some of the background for the case, and then we'll talk about the statute. So RD has a petition filed for carrying a loaded firearm in public and some other gun offenses. He gets detained and he motions unsuccessfully to be released a couple times in front of two different judges. During one of his requests for release, one of the judges repeatedly refers to him as a gang member, a gangbanger who has it in his blood, a gangbanger who has it in his culture. And the judge refuses to release him pending the next hearing. So RD files a motion to dismiss his case under the California Racial Justice Act, claiming that the phrase that he repeatedly used about being a gangbanger was made out of racial bias or racial animus. So with that context, 745A of the Penal Code, the state shall not seek or obtain a criminal conviction or seek, obtain, or impose a sentence on the basis of race, ethnicity, or national origin. I know those aren't usually the words conviction and that sentencing that are referred to in juvenile cases, but 745F applies this statute to juvenile adjudications. So specifically, what is a violation of the RJA? I'm not going to read this whole giant slide, but basically, if any person involved in the proceedings does anything that exhibits a bias, uses discriminatory language, even if they don't mean to, or if the person is charged or convicted of more serious offenses or sentenced more seriously than someone else similarly situated, and this is something that happens repeatedly in this particular office, that certain persons are prosecuted, charged, or sentenced more severely than people of other races or ethnicities. So that's a summary of what a violation would be. So once a motion is filed to allege a violation, the court has to decide if there's been a prima facie showing, so on its face, that a violation has occurred. If so, then they hold a hearing, and the violation must be proven by a preponderance of the evidence, which is basically more likely than not, 51% chance. So in this case, RD filed a motion with the juvenile court, not the same judge who was saying all those terrible things, seeking dismissal of the gun case. He alleged that the violation of the RJA was the judge's language regarding his being a gangbanger during the motion for release. So subsequent to that, he gets released on EMP pending another hearing. And then at hearing a couple weeks later, the court does agree that RD's made a prima facie showing of a violation, and the court ends his EMP. And then several months later, the court holds a full hearing on the motion and finds that the other judge did in fact violate the RJA, and the court now gets rid of EMP and the youth is just out on straight release. So at the hearing on the possible remedies that the court could implement, RD argues for complete dismissal of the charges. But the court says it doesn't think it has the authority to dismiss the charges, and it declined to rule on some other oral motions that he had made for dismissal, like under Welfare and Institutions Code Section 782. And the court denied his request to reduce the charges in the interest of justice, because the court didn't believe that a dismissal was a remedy that was specific to the type of violation. So RD subsequently appealed. So if the court finds a violation, here are the remedies that can be imposed. And these are the remedies. You'll see the little asterisks there. So I tried to document for you what the statute looked like at the time this case was decided. And the asterisks down below show you what it looks like now. So there's a distinction between the remedies that can be provided if the violation occurs prior to judgment, like prior to a conviction or prior to adjudication, or after, like for sentencing and disposition. So before judgment, the one that would have applied in a juvenile case would be C, if the court decides it would be in the interest of justice to dismiss an enhancement, a circumstance, an allegation, or reduce the charges. And if it's after judgment, the court can either vacate the conviction and order new proceedings, it can modify to a lesser included, or if it's just the sentence, it can vacate the sentence and resentence. And then provision 4, which is no longer numbered 4, but it was then, is applicable whether or not the RJA violation occurred pre or post judgment. So here the appellate court found first that the RJA does not provide for dismissal of charges as a remedy. And that is, it found that based upon the way it used to look before it was amended. Second, given that the language in subdivision E1 said the court may impose one of the listed remedies, the juvenile court did have the discretion to not impose one. And here, the juvenile court said it was not going to reduce the charges in the interest of justice because the court felt that wasn't a remedy that was specific to this particular RJA violation. This violation wasn't related to the charges. It was during the motion for release. And that was remedied because RD was no longer in custody. Third, the appellate court held that other remedies do exist, and that specifically under subdivision E4, you can seek dismissal under any other US or California constitution or law, something like, as I mentioned, 782 under Welfare and Institutions Code, that kind of a dismissal. But those things, while providing their own remedy under 4, they're not incorporated into the list of RJA remedies. So the juvenile court, when it denied relief, asked RD if he wanted to file motions for dismissal under other provisions, but he did not do that. He made oral motions, and the court declined to rule on oral motions. And finally, there was no evidence that the rest of the proceedings that RD experienced, either in his jurisdictional or dispositional proceedings, none of those had any taint from racial bias or animus. So going forward, I think some of these changes are definitely going to make a difference. In this case, under the way the statute looks now, might have been decided completely differently. So ultimately, I don't know that this case will have a whole lot of impact going forward, but I thought it might be really interesting for everybody to kind of see how it worked. So moving on, here's a restitution case, also interpreting a newly amended statute. So in this case, there's 2 minors actually, but the named minor is JL. So JL and OV and 2 other people are charged with various sexual offenses, possession of child pornography, sexual battery, false imprisonment, against a victim we're going to call Jane Doe. So JL receives 654.2 informal supervision, and OV receives non-wardship probation. Restitution is ordered at about $16,000 for each of the youth. That seems like a lot, but it's lost wages for Jane, it's lost wages for Jane's mom, it's expenses for babysitting and transportation services as the mother worked, and she needed someone who could take care of Jane and her siblings, because of Jane's victimization, she was not able to reliably babysit her siblings anymore. So JL and OV argue the joint and several liability order should have been apportioned among the 4 different co-participants. And they also objected to some of the mother's babysitting expenses as not being adequately documented. So the first issue is newly amended 730.6. As of January 1st of 2025, there is no longer joint and several liability for juvenile offenders. A victim is ordered now to receive 100% restitution as a total apportioned among all of the youth based upon their liability or the partialness of their fault involved in the crime. At this point, the court had already ordered the full amount for each youth to pay. So their argument was maybe OV was 20% responsible and JL was 30% responsible, and the other two boys were split between, say, 40 and 10%. But they were appealing the order that they should both be ordered to pay the full amount. So they appealed. So first of all, this case happened in 24, and that was before the law change became effective. So the court had to deal with the issue of retroactivity. And upon review, the appellate court found that the legislature, in enacting these amendments, did not intend retroactive application. The law itself doesn't say it. And in fact, the Public Safety Committee analysis actually used the phrase, "This bill would prospectively end joint and several liability." And additionally, the court found that Estrada didn't apply because restitution is not a punishment that can be lessened. It is a civil remedy to make the victim of a crime whole again. And for those of you that are unfamiliar with Estrada, it's just a case that stands for the proposition that when the legislature changes a law that lessens punishment, the courts can infer that it is meant to apply retroactively. So something simple like if the legislature was to change the punishment for a particular crime from 7 years to 5 years, that's lessening the punishment. And something like that, the legislature's giving the courts the indication that they want to make a change because they felt that their original punishment maybe was too severe. So that should apply retroactively. But in this case, courts and previously and this court have said that victim restitution is not a punishment. So the appellate court upheld the joint and several liability order for the full amount of restitution for both JL and OV because it decided the law wasn't meant to apply retroactively. And as to the other issue, the amount of restitution that was being claimed by Jane Doe's mother, first, we'll just establish that the mom of a victim is also considered to be a victim pursuant to the California Constitution. And when it comes to determining an amount, restitution law is clear that a court may accept a victim's statement and an estimate. The court isn't required to ascertain the exact dollar amount of a loss as long as the amount has some factual nexus to the damage that was caused. So in this case, the mother actually documented 30 specific dates where she had hired a babysitter for either $120 or $150 for the day. And occasionally she threw in some extra money if it was necessary that the babysitter feed the kids. And the court felt that that was more than enough evidence to support the restitution order, even if she couldn't provide proof of the exact amount for every day. Okay, now we're going to jump to a few cases that deal with juveniles whose cases were transferred to adult and they were convicted and sentenced by the adult court. And you're going to see these cases happened quite some time ago. The first one is People versus Superior Court. It's Mr. Valdez. Mr. Valdez was sentenced to life without the possibility of parole for a murder that he committed when he was 17. In 2018, he petitioned the court and was resentenced to 50 years to life, pursuant to Penal Code 1170. So 1170 D1 allows a juvenile offender sentenced to LWOP to submit a petition for resentencing after they've been incarcerated for 15 years. So he does that. He gets his sentence reduced to 50 years to life. In 2024, he files again for resentencing. This time, it's under 1170 D10. And that provides that if your sentence is not recalled under D1 or you're resentenced to LWOP, you can petition again for recall and sentencing at 20 years, at 24 years, and 25 years. So Mr. Valdez is arguing that his new 50 years to life sentence is the functional equivalent of LWOP. And under a case called Heard from 2022, he's entitled to resentencing. The Heard case basically held that equal protection requires, if you get relief under 1170 for LWOP, you should get relief for the functional equivalent of LWOP, basically some sentence long enough that you probably would die in prison. So the trial court agreed with Mr. Valdez and that the 50 years to life was a functional LWOP, and it granted the petition. And the prosecutor petitioned for a writ of mandate, meaning the prosecutor basically was like, hey, the judge was wrong. Please, appellate court, order the trial court to deny this petition. So the appellate court held that the Heard case doesn't apply to petitions under 1170 D10 if the person is eligible for youth offender parole under a sentence imposed at resentencing under 1170 D1. And that youthful offender parole comes into play because of Penal Code 3051. It entitles a person who was a juvenile at the time of their offense and sentenced to LWOP to youth offender parole hearing in the 15th, 20th, and 25th year of incarceration, depending upon what the offense was. So here, Mr. Valdez's sentencing to 50 years was not the functional equivalent of LWOP because he was resentenced after the enactment of PC 3051, and he had parole eligibility during his 25th year of incarceration. And in fact, he'd already had a parole hearing at the age of 42. So the appellate court granted the people's petition and directed the trial court to vacate its order granting the resentencing. The next case is similar. The statutes are there for you. Mr. Olmos was convicted of murder and other things at age 17. He was sentenced to 33 years to life in 2001. In 2003, he filed a petition for recall and resentencing under 1170. The trial court denied his petition, believing 33 years to life was not functionally equivalent to LWOP. So you can see there, the first two bullets are similar to the ones from the prior case. And here the appellate court affirmed the trial court ruling and held that the defendant's sentence was not the functional equivalent of LWOP. 33 years to life is not functional LWOP, like some of the other cases that with much larger numbers, 23 plus 80 years, 10 plus 130 years. And in fact, Mr. Olmos had already been entitled to a parole hearing in December of 24. And finally, the last case in this particular vein, same thing, same provisions. Mr. Munoz was 15 at the time of a murder, and he was sentenced to 50 years to life. After 15 years, he petitioned for recall and sentencing, and the court denied the motion, stating that he would be eligible for youth parole under 3051 in 2029, when he would be 39 years old. Mr. Munoz appealed, and this court took a different view than the other two courts. It basically held that he was not eligible for recall and resentencing because 1170 D1A plainly limits its application to explicit LWOP. And then it went on to say that 50 years to life is not the functional equivalent of LWOP anyway. And the court declined to engage in kind of an assessment of statistical analysis of life expectancies, and went ahead and distinguished Mr. Munoz's case from some other cases with 50-ish to life sentences, because this was a murder case and those other cases were not murder cases. And he felt like the reasoning in some of the other cases like Contreras was that murder is different and viewed differently than non-murder cases. And also that the Contreras case was an Eighth Amendment case, a cruel and unusual punishment case, and Mr. Munoz did not raise that issue here. But as you can see from the third bullet, this case is currently pending review. And I think because it's an outlier from some of these kinds of cases, I think it's probably not the final word on this case. So I am done with my summaries. If there are any questions. Okay, then I'll turn it over to Mika.
Thank you so much. That was a beautiful presentation. And I want to thank everyone for joining today's session. Please thank me in joining both our speakers today for an informative presentation. And we welcome you to take the survey to provide feedback on your experience on today's webinar. The link will be available in the chat. This webinar recording will be available on the OYCR website by the end of this week, and the slides will be sent to you in a follow-up email. And the next webinar in the Youth Justice Action Series will be February 17th at noon. And you can use the link in the chat to register. And that concludes today's webinar. Thank you everyone for joining us. We hope to see you next month and have a wonderful afternoon.